So the Supreme Court basically ruled this week that gun manufacturers can be sued for bad people using their products, which is just an absurdity. According to Hank Berrien, writing over at Daily Wire, this week the Supreme Court ruled it would refuse an appeal from the Remington Arms Company of a Connecticut Supreme Court ruling that permitted relatives of Sandy Hook Elementary School shooting victims to sue Remington. The shooter in the Sandy Hook shooting used arms made by Remington. The New York Times wrote the case has been seen as a test of the ability of plaintiffs to pierce the legal immunity of firearm manufacturers in the aftermath of shootings. Okay, so here is the actual full story. So the way that they make this sound is that they make it sound as though there is special immunity granted to gun companies that do not apply to other companies. Now, legally speaking, that's sort of true, and it's mostly not. So the reason it's sort of true is because there is a law specifically on the books that prevents the suing of gun manufacturers for bad people using their products. But the only reason that that law was formulated in the first place is because there was bad application of law in a lot of the states. So typically, when it comes to products liability, right, if there's a tort, there's only a couple of ways that you can sue the manufacturer of the thing that hurt you. Right? There are a couple of different types of defects that you can sue under. Okay, design defect. So a product was designed and it was defective as it was designed, and therefore it did not fulfill its purpose. Right? The product was flawed from the very beginning in the design. Like you designed a car and the engine blows up as soon as there is some sort of car crash. Right? That'd be a design defect. Then there's a manufacturing defect, which is the car was perfectly designed, but in the process of manufacture, then there was a flaw that cropped up, and now the car blows up when you hit somebody. And finally, there's a marketing defect, and that is that something is marketed improperly, right? They say that the product can do something that it can't do. The product says that it is, in fact, inflammable when it is completely flammable, right? That's a marketing defect. Now, the problem is that when it comes to a bad person using a gun, the gun manufacturer was not involved in either a design defect, a manufacturing defect, or a marketing defect. Right? There's no design defect. The gun operates as it was supposed to. There's no manufacturing defect. The gun operates as it is supposed to. And there was no marketing defect because at no point did Remington say, if you want to rob a bank, buy our gun. Instead, they said, if you wish to buy a gun, here is how the gun operates. And then somebody bad bought a gun or used a gun. And then the manufacturer was sued. Okay, so there were a lot of people launching lawsuits against manufacturers because that's the deep pocket. It's very weird in Sandy Hook's case because in that case, the gun was apparently legally bought by the parents, and then the kid took the gun from the parent after shooting mom and then went to the school and started shooting up the kids. Somehow this is the fault of the manufacturer, Remington, right? So normally this makes no sense, right? It makes like no sense, legally speaking, to sue Remington. But what happens is that if you're a good lawyer, what you know is that all you have to do with a case like this is get it in front of a jury, because you get this in front of a jury and you sit there and the jury rightly is going to look at the victim, in this case, the parents of a kid who's been murdered, and they're going to say, okay, those people have no money, and here's Remington, the company that made the gun, and they have lots of money, so let's give them each $10 million. Let's give them each $10 million, right? And that can bankrupt a company. So back in 2005, there were a lot of cases like this in the early 1990s where gun manufacturers were basically being sued out of business by various private parties at the behest of states, liberal states. Okay, so in 2005, there was a bill that was passed that said, okay, we can't have lawsuits that are being launched on false auspices in order to go get a gun manufacturer just because you don't like gun manufacturers. And so they passed that law. So now there's this lawsuit by the Sandy Hook family, and the Connecticut Supreme Court basically overrules the federal law, which is incorrect. And the Supreme Court says, okay, we're going to allow the lawsuit to stand. It's bad policy. It's bad politics. It's bad law. It's very stupid. It doesn't make any sort of logical sense. It makes emotional sense. It doesn't make any logical sense. And so what you're starting to see is companies like Remington that are carving off sort of separate LLCs to limit their liability. Right? An LLC is a limited liability corporation. So what they're starting to do is they will have, if they're being sued under the auspices of marketing defect, then they will carve off Remington Marketing, for example. So that way, if Remington Marketing gets sued, it doesn't bankrupt the rest of Remington Manufacturer, for example. And all of this is not good for the law-abiding gun owner who just wishes to purchase a gun. None of it is actually good for legal fairness in the country, because you shouldn't be able to just sue a company because you don't like a bad person use their product. It's like suing a knife company because O.J. Simpson stabbed Nicole Brown, right? Like that would be a very bizarre application of tort law. And yet, this is exactly what the left wants to do. The left has tried every avenue they can think of to bankrupt gun companies. They've suggested, for example, that gun companies be treated as though they are creating a public nuisance, as though they are polluting the air, which is idiotic. Because again, I have several guns sitting in my house right now. They are not affecting my neighbors. Okay, it is not the same as a gun manufacturer spewing toxic waste into a lake or something. So they've tried to say that this should be treated as also a disease, that the Center for Disease Control should study gun violence, which is absurd. Gun violence isn't disease. Okay, I don't know under what rubric you would suggest that gun violence is a disease. It is a crime. Would you study robbery as a disease? It's a very weird sort of thing. And would you study robbery, like armed robbery, as a disease? So only if they're carrying a crowbar, you then have to investigate crowbars as part of the problem? Well, all of this is designed by the left to go after gun manufacturers and destroy them and harm them. And that's why the Supreme Court ruling is so indubitably dumb. It's not only dumb, it's incredibly damaging. So, so much for the conservative Supreme Court. I mean, presumably there should have been 4 votes. In order to take up the writ of certiorari, all it takes on the Supreme Court is 4 votes. I'm wondering who are the 2 who didn't go for it. My assumption would be Kavanaugh and Roberts, right? Because there are 5 votes that have been appointed by Republicans in recent years. I would assume that Alito and Thomas and Gorsuch all voted to take up the case. I would assume that it would be Roberts and Kavanaugh who didn't want to take up the case. But again, that is speculation. We don't actually have information on that. It's a very dangerous ruling, and it does not bode well for the future of gun rights in this country. You bankrupt every gun manufacturer in the country, it's going to be very difficult for anybody to access the guns that they ought to have under the Second Amendment. Remington's appeal was titled Remington Arms versus Soto. The Connecticut case was Soto versus Bushmaster. The Times noted that the Sandy Hook family's suit had used one of 6 narrow exemptions to the 2005 law to argue that Remington violated Connecticut's Unfair Trade Practices Act. The suit said the gunmaker recklessly marketed the AR-15 style rifle to disturbed young men through product placement in violent video games and advertising pitches like "Consider your man card reissued" and "The opposition will bow down." Well, again, that would be presumably in a video game. I don't think anyone really believes that Remington meant to sell weapons to violent criminals who kill children. In a brief filed by 22 members of the House of Representatives that supported Remington's appeal, they wrote, "In enacting the Protection of Lawful Commerce in Arms Act of 2005, Congress expressly recognized that lawsuits seeking to hold manufacturers and sellers of firearms liable for the criminal conduct of third parties were not only without foundation in hundreds of years of common law and jurisprudence of the United States, but also improperly sought to use the judicial branch to circumvent the legislative branch of government to regulate interstate and foreign commerce through judgments and decrees that weaken and undermine important principles of federalism, state sovereignty, and comity between sister states." And of course, that is true. Connecticut Senator Richard Blumenthal, who's a radical on the gun issue, he issued a statement saying, "Sandy Hook families have successfully surmounted a sweetheart federal statute favoring gun companies." Again, it is not a sweetheart federal statute. It is merely a recognition that the left is abusing tort law and will continue to abuse tort law in order to go after, on the one hand, pockets that are deep, and on the other hand, causes that they don't like. Thank you for tuning in to the Daily Wire, one of the fastest growing conservative media outlets in the country. If you enjoyed this video, be sure to give it a like and subscribe to our YouTube channel so you don't miss out on any of our content.